Donald Trump awaits criminal trial. There's a big hearing Thursday, and we're joined by David Kelly, former SDNY chief and my former boss. Welcome back, David.
Good to be back. How are you?
I'm good. We'll get to the hearing. I want to pick up one more statement from DA Bragg. And I mentioned to viewers, in all candor, he's not exactly making news, revelations or new statements about what he already laid down. The threats, though, are pretty real, and he has spoken about that. Here's some more of what he said.
I don't think a ton about my personal safety because I know that they are the best at doing this. I do worry as a employer, and we have more than 1,500 people who work at the Manhattan District Attorney's Office, and they're coming and going throughout lower Manhattan, and we worry about the neighborhood, and so I shouldn't say worry. We think about and thoughtful and sober about it. But given the NYPD's expertise and preparation and all they've done, it's not something that I'm spending a lot of time thinking on.
That's sort of the way that the DA refers to it, David, and it would be easy to think that these are the normal precautions you take. They deal with a lot of cases. I've met with DAs. They have a lot of security, which, if you're not involved in this day-to-day, reminds you that they prosecute violent criminals, gangs, folks with even international connections out of New York, and they deal with it. But what's not normal is he is referring indirectly to the threat that some person, might take such dangerous action against his employees or anyone in that office because of statements online and elsewhere by a former president of the United States. What does it tell you that this is still part of the DA's brief right now?
So I think we've kind of moved away from concern about the prosecutors and their safety, because that was, came out, we're kind of past that. What I think the DA is focusing on more now, but has not turned his back on that stuff, but more focused on two things. One is intimidation of witnesses, and perhaps more important, polluting the jury pool. And not just polluting the jury pool, but also kind of intimidating the jury pool that will ultimately decide his fate.
Yeah, interesting. And you're kind of reminding us there's more than one way that these kind of statements can play out. As for the hearing itself that's coming up, Mr. Pomerantz has been louder than the DA, that's for sure. They initially tried to see if they could find some way to avoid this, but because he's, I guess, a former government official, that proved harder, and he will testify in this closed-door setting. What can he do if he wants to maintain privacy or privilege where warranted in this setting? And do you expect any of it to leak out, given that the Republicans seem to want to make something of this on the committee?
Oh, the second question's the easier one. There's no closed hearing where things don't leak out. I've done many congressional hearings with all sorts of assurances that nothing's going to leak out. And before you get out the door, it's on headlines. So, with regard to the privilege, I think a lot of it, a lot of the toothpaste is out of the tube. So I don't know how much he's going to be able to limit what he says. But I want to come back to how that could really impact the other issue about the protective order. And I don't think, the fact that Mark has come out and said these things really hasn't any bearing, I think, on the protective order, because that wasn't in the control of the district attorney. And what the district attorney has done is he's come out with an indictment and he's come out with a statement of facts. But those are statements that were made in connection with the court proceeding. Those are public statements in the court record. And what they're looking here is to preclude the former president from taking information from the evidence and using it as a weapon to either intimidate jurors, witnesses, or to pollute the jury. I think that it will be, in terms of going back to the Pomerantz hearing, sure, he can say some stuff that will kind of add to that in terms of polluting the jury. But I don't know that there's anything that he's going to say that is going to be helpful to the president. And the fact that, some of his, allies are the ones who's eliciting this information, maybe want to think twice about whether or not, whatever their mission may be, if it's to help the former president, I'm not sure this is something or a road that they maybe ought to be going down.
And on the evidence, then, do you think there is a decent case to be made that some of it shouldn't get to Donald Trump? Because most defendants, whether it's Brady material or anything else, are supposed to get most stuff.
So I don't think what he's trying to do is preclude his access to evidence. He's precluding his unsupervised access to evidence so that officers of the court, such as his attorneys, could preclude his misuse of that information. And the protective order will help do that too, because even if he sees information that he'd like to put on Truth Social, the protective order will preclude him from doing that. So I don't think this, it would be a different argument if they're saying you can't even see this evidence. That's a much different row and a difficult row to hoe for the district attorney. What I think they're doing here is saying, look, we'll let you see the evidence, but you're not going to see it unsupervised. And with the protective order, you can't go out on Truth Social or wherever you're going to go and publicize it.
Yeah, understood.
And that's
go ahead.
Really unusual. It's not really, you love this, but I mean, you're right. In one of the statements that you made, this is not typical. It's not typical that you have to get a protective order because it's not typical that a defendant is going to get on Truth Social and with, have 8 million followers looking at the things that he puts out there with all sorts of suggestions of bad things you can do to people. Where that comes into play is like if you're doing a mob trial. I mean, when we used to do a lot of mob trials, that we get protective orders to preclude them from using evidence or publicizing certain evidence so that, again, witnesses and jurors are not intimidated so there can be a fair trial.
Yeah, well, you make several great points, including the experience you draw on. And yeah, the fact that any of this with regard to the defendant and the risks is like a mob trial is really telling.